Why isn't it logical, as the court said in Husbadrami, the Second Circuit unanimously, why shouldn't we treat the querying of U.S. persons out of this dragnet database, why shouldn't we treat that as a separate Fourth Amendment event requiring some additional process? Maybe a warrant, as Senator Lee has proposed, maybe some other process, but why shouldn't we say, actually, yes, when you go to this massive database and ask about a U.S. person, that's a Fourth Amendment event that requires some process, some scrutiny.
Yes, and so there are two answers to that. One is a legal answer, and we've covered that a lot, but in short, we don't require the FBI agent to get a warrant before going to check the filing cabinet.
Yeah, but this is totally analogous to that, as the Husbadrami court said, right?
Sensitive records.
And as indeed the U.S. Supreme Court said in Riley. I mean, this is a completely analogous to saying that you have a piece of information down in a locker somewhere that you got pursuant to probable cause and indeed a warrant for a particular case. Here you have a massive dragnet of information. You just told me a second ago that you couldn't target the American citizens. So none of this information with the American citizens has received any process whatsoever. But now the FBI or the NSA, whomever, can go and query this database for the first time and get information on U.S. citizens, particularly for the first time. And you're telling me that that's not a separate Fourth Amendment event?